What if I told you that the same law used to take down the mafia can also be applied to the banks and debt collectors? And today I'm going to be breaking down 18 USC 1961, the federal Rico law, and how it exposes banking practices as racketeering. Now, before we dive into this video, this is not legal advice. This is not financial advice. This is only for educational purposes only. All my rights are reserved. Number two, hit the follow button, hit the like button, hit the subscribe button, because we're going to be diving into something that the banks don't want you to know that they're doing. Okay. So before we dive into it, let's go ahead and talk a little bit about the aspect of 18 USC 1961. 18 USC 1961 particularly talks about the definitions and rules as it pertains to fraud and racketeering. Okay. And what it defines racketeering is any act, threat involving murder, kidnapping, gambling, arson, robbery, bribery, extortion, dealing in an obscene manner, or dealing with a controlled substance or illicit chemical, which is chargeable under state law and punishable by imprisonment for more than 1 year. Okay. Now, I wanted to bring up this because this is part of what the banks are doing. Okay. And I'm going to tie it back in a second. So we're going to be doing a deep dive on 18 USC 1961 and the aspect of racketeering and how it applies to what the banks are doing and what makes what they are doing a potential RICO. Okay. Now, make sure you stay all the way to the end so that you know the full legal application on how to be able to use this against a debt collector. Now, first things first, I want to dive into the aspect of 18 USC 1961 and the basics of what a RICO is. Okay. Now, 18 USC 1961 is the definition section of the Racketeer Influence and Corrupt Organization Act. Okay. It lays out, which is RICO, it lays out what counts as racketeering activity, which is mail fraud, wire fraud, extortion, obstruction of justice, financial fraud, bribery, money laundering, and more. And it also defines what qualifies as an enterprise, which is any group, company, or association that engages in racketeering as a part of its operations. To prove a RICO case, there must be a pattern of racketeering activity and at least 2 predicate acts within a 10-year period. Originally designed to go after the mafia bosses and organized crime families, and the RICO's definitions are broad enough to apply to banks and debt collectors when they engage in systematic fraud and abuse. Okay. So just from that alone, you can really start to think of some of the ways that the bank may be doing things such as extortion, maybe doing things such as robbery, maybe dealing in an obscene manner. Okay. Maybe even money laundering. All right. You can easily argue that. But let's just talk about how the banks can fit that definition. Okay. So the banks are corporations. Okay. So they legally qualify as an enterprise under a RICO. And if they engage in a pattern of fraud, misrepresentation, or extortion-like behavior, they meet the statute's definition. So here's an example of mail fraud and wire fraud. Sending false billing statements and securitization fraud, meaning that you securitize it without my knowledge. Okay. Extortion, threatening foreclosure, repossession, or anything of loss on already paid assets. And then obstruction of justice, withholding documents like the original promissory note, like the accounting activity, like the itemized, numbers, right? The original creditor, certified copies of the chain of assignment, things in that nature. Mail fraud, extortion, and obstruction of justice, that plus the corporation can be racketeering, which is a criminal offense. Okay. If I go to Title 18, I think Title 18 deals with all crimes and criminal procedures. Okay. So there it is. Crimes and criminal procedures. You dig what I'm saying? So again, this wouldn't be put in place if it wasn't a crime, right? It's a criminal offense, what we are talking about here. All right. So now that we know that the banks fit the definition of an enterprise, let's dive into the aspect of what patterns that bankers may make that may show racketeering, because again, you have to be able to approve patterns over a 10-year period. So banking collectors commit acts that fall neatly into Rico categories, such as mail fraud and wire fraud, sending false billing statements, reporting fraudulent debts to credit bureaus, using mail or electronic systems to push unvalidated claims. So if they send you anything that claims that, if they attempt to collect on a debt, whether it's electronic or mail or whatever the case may be, without doing the proper validation after you ask them to, anything after your initial challenge now falls under the category of racketeering. And they'll try to flip the script on you and make you think that you are doing something frivolous under 18 USC 514, which talks about frivolous filings. They'll give you the idea that that is what you are the one committing fraud, but it is actually them. Because as simply as sending a billing statement without a legend that will indicate that one has to pay, or whether it is something that could be monetizable or acceptable for value, now falls under potential racketeering. Okay. And then we dive into extortion. All right. Extortion, when they start to threaten foreclosure and doing things like repossessions, right? When you have already started your administrative process with them, like after you have sent them letters and you're challenging the validity of a debt, or you're challenging the securitization, or you have already made a truth that it has already been paid, and they still decide to repossess without rebutting your claims, that can fall under the category of extortion. Okay, because if they securitize it or it is insured, then they have been made whole. Okay, so again, if you get into a loan agreement and you're in a loan agreement on the premise of they are loaning you money and you're going to pay them back because they loaned you money, then that makes sense. But if the reality is that there is some hidden information that when I sign this, it's not that you're going to loan me money, you're going to give me money that I created. Okay. And then after you give me money that I created, I'm going to pay you for money that is not even in your reserves and is money that I created. Okay. Just that deception in itself falls under the category of racketeering. Okay, so forcing consumers into payments under duress by withholding key documents like the original notes. When you start to send your challenge, when you start to send your qualified written request, when you start to send your conditional acceptance, and they decide to not give it to you or claim that they don't need to give it to you, that will be extortion. Okay. Then we dive into securitization fraud, selling your note to investors multiple times. Securitization fraud, still enforcing the debt against you even though the obligation was already monetized, falls under securitization fraud. It's funny how everything that I say is in terms of the way they can violate your right to lie or bullshit you, falls under can easily be built up a case for Rico. Now, obviously, I bring this up because I'm not trying to sit here and say that you can go after them for a Rico case and you could potentially win. But not only does it affirm that this is things that they're doing, but also at the same time, if you start to shift that onto them, when they start to shift some things onto you, now you're able to play a game much differently. Because when they send you something and say that you're committing a fraudulent act, but then you send something back to them, you may not know what to say back to them, but you come back and you say, well, no, you're the ones committing a fraudulent act because of this, this, and this, which can fall under the category of extortion, mail and wire fraud, credit reporting fraud, which in Title 18 says that that is considered racketeering your enterprise. You can see how they respond, how they disprove the fraud. You know what I mean? Another thing is when they report to your credit report without your knowledge, your consent. If you decided to opt out, they still reported, or if it's invalidated claims. So knowingly reporting false information or inaccurate information on your credit report can be considered a credit report fraud. We could dive into continue to report after you have disputed without validation. And we can also talk about any transmission of false data can equal another act of wire fraud, because technically, how did they receive the information? You mailed it to them, you know? So again, it is a very a thin line of what they have done and what they are doing that can fall under the category of racketeering. And the whole point of me bringing this up again is because this is the gravity of what they are doing. And this is exactly why we do the things that we do and why it's okay for you to do what you do. Because at the end of the day, they're committing, class A felonies, Things they're about to take. They was trying to take down Young Thug and Gunna and all these people. We watch the cartel movies and all that. They talk about Rico case this and Rico case that. It doesn't always have to just deal with drugs. Sometimes it's something fraudulent going on. Okay? And most businesses participate in stuff like this. Okay? And I'm talking about big businesses. Because the banks and collectors repeat these acts daily, they'll meet the RICO standard of a pattern, which, again, over the last 10 years, if they commit these acts, then you fall into the category as RICO. Now, obviously, it'll have to be a big case for you to be able to take down a bank. Okay? Now, let's talk about why this has legal merit behind it. Okay? Civil RICO lawsuits are not just symbolic. They are some of the most powerful legal weapons to use because you can take this to a civil side instead of it making it criminal. Okay. Victims can sue for damage for 3 times the actual damages sustained. So if it's $1,000 violation, that can be a $3,000 violation. Attorney fees are recoverable, making it easier to find representation. So typically, if you feel like you're in a RICO situation, a civil RICO situation, you can go after you have built a case and you can inquire with an attorney and you can pretty much say, hey, this is the case I have built up against them. And we can potentially get some money out of it. But also at the same time, your fees will be covered. And the stigma of being accused of racketeering actually makes banks more likely to settle. The harder that you press on in terms of their acts that may be criminal or civil, the bigger those violations, the more that you're able to stack up against them, kind of positions them to want to settle. And if you don't want to go to court, then you have to take the laws, the evidence, and the communication serious prior to going to court. Okay? Usually if you go to court, it's probably because you didn't build up enough evidence nor back them into a corner to where they have to settle with you. Okay? So even if you as a consumer don't pursue the full RICO case, just citing RICO statutes in correspondence or complaints reframes the narrative because, again, you can make it about debt discharge, but we're trying to make it bigger than this $1,000 debt, $2, $3, $4, $10, $20, $30,000 debt. It's bigger than that. I've experienced some actual damages, some actual harm that's bigger than this money that you claim I owe you. Not only are you lying about that, and I want you to prove that, but here are some other ways that you have committed fraud against me, which now begs the question bigger than a debt to take the focus off what you owe and more the focus on how they've been carrying out this very contract that they claim that you guys got into, that they are attempting to enforce. So instead of being a debtor in default, you show that the bank may be engaging in some organized criminal activity, again, which requires a little bit more scrutiny than the civil case, okay? This shifts the leverage and suddenly the institution fears the scrutiny because the RICO has been used successfully against the financial enterprise in the past. So most financial enterprises, once you start to challenge them on a RICO side, this right here typically shifts in the favor of whoever asserts those claims against them, okay? So let's just go ahead and bust the myths that banks are untouchable. The reality is they aren't, okay? Most people would think that the banks are too big to challenge, but the reality is a RICO was written in place to pierce corporate shields. And it doesn't matter how big an enterprise is, if it engages in fraud or extortion, it qualifies. This is not your end-all be-all conversation, but just putting in there that there's some level of racketeering activity again shifts the narrative. Number 2, these laws are only for mobsters. The RICO applies to any enterprise committing a pattern of racketeering. Courts have applied it to corporations, unions, political organizations, and yes, banks. So again, if it's an enterprise that's participating in any criminal acts, it can be tried for a RICO. Myth 3, you can't prove it. The reality is every billing statement, every inaccurate credit report, every false affidavit in foreclosure court is potential evidence of wire fraud or mail fraud, and each act builds a pattern needed for RICO. So if you can show the continuous reporting on your credit report, if you can show the letters of misrepresentation and the lies, if you can show every billing statement that, again, has a coupon attached to it, and you can show the documentation where they dishonor it and they don't allow you to use it, you're pretty much building up a case of something that you can prove, because they would have said it for themselves or would have already been doing it. Again, this is something that they already do, so the pattern is already set. And if it's a true pattern, then yes, it definitely is a Rico case, and the court won't take you serious. The reality is courts must take Rico pleadings serious because the statute mandates 3 times damages. Okay, many cases settle quietly to avoid the risk of losing under a Rico. That bank doesn't want a Rico to be put on through the public eye. Okay, they prefer to be invincible. Okay, and I would call that, like, they want the illusion that they are invincible, but the reality is the Rico is designed to cut through this systematic base. So let's now really just break this down in this big picture, okay? The same laws built to dismantle crime families can be used on modern banks. And who's to say that these modern banks aren't ran by criminal organizations or criminal families as we speak? Who's to say that they aren't money laundering? But once you start to pull up these questions, what typically happens? Now we have to really do a full audit of this company. Okay, now we have to truly see what's beneath the surface, okay? Because when they securitize notes, misrepresent ownership, enforce fraudulent debts, or harass consumers, they step into the definition of racketeering. And again, racketeering is a grave offense, but when you start to bring these questions up, again, everybody will always ask, okay, well, what does this have to do with debt discharge? You are building a case at the end of the day, a case of non-compliance, a case of some fraud, a case of some negative activities that will pretty much give you a reason to not pay, right? Like if your ultimate goal is to stop paying, you should provide a valid reason not to pay. And if we're going on the premise that somebody loaned you money, $100,000, you used up the $100,000 and now you don't want to pay, if that's what's going on, then you need to pay. And if that's what's in the eyes of the judge, and that's their perception of the judge, not only the judge but also the attorney, if that's the perception that they are painting a picture of, that's what's going to happen. But when you change the perception, when you say that there's some racketeering involved, you said that you've actually reached out to them, you said that you're not actually trying to breach the contract, you're trying to make sure the contract is valid. When you start to move with this energy, typically what happens is there are more questions that have to be answered, that they can't just easily just say, oh, well, we're not going to take this serious. Because again, I'm not making it about the money. I'm not making it about me not paying. I just want some questions to be answered, and I have well within my right and well within the law to do. That's why you guys have the USC in place. That is why you guys have the UCC in place. Well, equity doesn't apply. Well, under UCC 1-203, it says that equity actually supplements the UCC. So beyond the aspect of the templates and letters that you'll get, whether you're in the school community, whether you purchased the complete debt guide in the past or whatever the case may be, you have to know it and be able to communicate it so that you can be able to paint the story and create your own narrative instead of them creating a narrative for you. All right. So knowing this can shift your posture in the courtroom. Now you are bringing up not just the civil case that they can just gloss over, and now you're bringing up a criminal case as well, because you're not powerless. Okay, you're a potential plaintiff with a Rico, and you've seen what Ricos have done to rappers, the cartel. You watch the movies and see how serious they take it. So yeah, once you do that, now it gets taken serious. So 18 U.S.C. 1961 wasn't just created for mob bosses. It was written for any enterprise running patterns of fraud and extortion. So if you feel like you're being extorted or something fraudulent, once you see the banks through that lens of somebody that could be potentially extorting you or committing fraud, you'll understand why they never fear informed consumers more than anything else. Okay? You're gonna see why they wouldn't want this video to come out, because they wouldn't want people to be claiming that they are racketeering. Okay, so if you want me to do more of a deep dive into Rico claims, drop it down in the comment section down below. Okay, if you have already done it, drop it down in the comment section down below. Let everybody know your experience. Number two, if you want to learn more about this and connect with the community, okay, that is engaged in learning this activity and taking this activity serious, tap into the school community. It's only 27 bucks a month. Okay, you can get in for free for 7 days. Then after that, it's 27 bucks a month. Lastly, if you want to work with me one-on-one, and no, I'm not about to sit here and settle no criminal case for you, and no, I'm not about to sit here and discharge your debt for you. But what I will do is, if you are looking to build your credit, if you are looking to get funding, start a business, start a brand, if you are looking to do those things and work with someone who's already done it one-on-one, tap into that one-on-one application down below. Thank you guys for watching this video. Very different video, talking about more on the criminal side, and got off the civil, but we still brought it back to private banking. Let me know what you guys think about this. You guys want me to talk a little bit more on the criminal side? You guys want me to continue to talk about the civil? Let me know. Thank you guys for watching this video. I love you guys, and I'll see you in the next one. This video is sponsored by the Fund Yourself Academy. My step-by-step system designed to help you fix your credit, get funding, and build real financial freedom from scratch. If you're tired of feeling stuck, overwhelmed, or just ready to stop living paycheck to paycheck, this is where it changes. Inside the Academy, I break down everything from consumer law secrets that they don't teach in school, to how to remove negative items and boost your score, get access to business funding, and start building multiple income streams online. Whether you're just starting out or ready to level up your game and get the bag, this is your playbook. We've got tools, templates, dispute letters, mentorship calls, private community access, and an exact roadmap I use to leave my 9-to-5 and create time freedom. But only for a limited time, you can get access to the Fund Yourself Academy on a free trial basis for the next 7 days. And then after that, you pay less than $1 a day at 27 bucks a month. If you like it. No fluff, just facts and just freedom. Go to the fundyourselfacademy.com or hit the link in the description to join now, because nobody's coming to save you, but you can fund yourself.